Welcome all of you to our presentation today on consumer privacy. We are very excited to provide this information to you all. I first want to introduce our two speakers. First, we're going to have Director Katie Haas. She is the director of the Utah Division of Consumer Protection. She has a team of over 30 individuals that she works with. They investigate claims and bring enforcement actions under Utah's 26 consumer protection statutes. Some of those include the Consumer Sales Practices Act, the Utah Consumer Privacy Act, which we'll discuss today, and the newly enacted Utah Minor Protection in Social Media Act. Under Director Haas's leadership and in collaboration with other stakeholders, the division has brought many high-profile actions on behalf of consumers, including those against social media platforms and insulin manufacturers. Director Haas obtained a BA in Economics and Political Science from the University of Vermont and has a law degree from the BYU Law School. She graduated there from cum laude. Prior to her appointment, Director Haas worked as legal counsel to several consumer good companies and provided legal services to several federal agencies. Also today, we will hear from David Sonnenreich. He is the director of the Attorney General's Antitrust and Data Privacy Division. He is also the chair of the Utah Privacy Commission and a voting member of the Utah Cyber Security Commission. His undergraduate and law degree are both from the University of Utah. He also has a certified information privacy professional certificate. Mr. Sonnenreich has represented the state of Utah in numerous high-profile data breach enforcement matters, such as data breaches that have impacted Equifax and Uber. He has worked closely with legislative sponsors on a variety of data privacy bills, including the UPPIA, the Utah Protection of Personal Information Act, which I believe he'll mention today, as well as the UCPA, which we will go into depth into, and the Utah Government Data Privacy Act. So with that, I will welcome Director Haas to the stand. Thanks.
Thank you, Lana. And for those of you who didn't catch that, that's Lana. She's one of the attorneys in the Attorney General's office who does phenomenal work in this space. So just to give you a brief overview before we dive into the slides, some of you may be wondering why the Division of Consumer Protection is kind of speaking of themselves separate from the Attorney General's office. While in most states, the consumer protection is under the purview of the Attorney General, in the state of Utah, we're a little bit unique in that consumer protection falls under the Department of Commerce. It's been that way ever since consumer protection actually, consumer protection predated the Department of Commerce and then came in under the Department of Commerce back, I think, in the 60s or the 70s. So we've been around for a while, and we have this kind of unique hybrid approach in which the Division of Consumer Protection can bring administrative enforcement actions. It can also bring cases in district court, but with the advice and counsel and with representation through the Attorney General's office. So we spend a lot of time working and collaborating with the Attorney General's office. But initially, when consumers come in and they have complaints about things that are related to deceptive acts and practices, or in this case, the Privacy Act, they're going to be funneled and start with the Division of Consumer Protection. So today we're here to talk about the Utah Department of Commerce's Division of Consumer Protection's Consumer Privacy Act. And the goal of this presentation today is just help people understand this new law, how it impacts consumers, as well as the impact on Utah businesses and some other businesses that are dealing with Utah consumers. Okay, just by way of background, the mission statement for the division is to strengthen trust in Utah's commercial activities by protecting consumers through education and impartial enforcement. We feel that it is really vital to our community that we have trust. Trust is the framework under which everybody engages. And in Utah, we have a really incredibly high trust society, which I think is one of the main reasons why we have such a strong economy. And so at Commerce, we really focus on how do we build that trust? And when people break that trust, potentially through bad actors in any space, how do we restore consumers' trust in that, or have businesses have a level playing field so that one bad actor doesn't ruin the bunch? We have 26 statutes that we enforce, as Lana referred to, and then there's others that we collaborate on. Most notably here, I've called out the Consumer Privacy Act because that's what we're talking about today, but also the Consumer Sales Practices Act is a statute I'm going to briefly touch upon because they are related. Okay, so the Utah Privacy Act is here. It was enacted it went into effect in December 31st of 2023. And basically it has information for consumers that what they have a right to know about the data that businesses are collecting from them. And then they have a right to do certain things with that data and ask businesses to do things with that data. And then there's things that businesses are obligated to now do. Just by way of reminder, this was one of the first laws in the nation to come out on privacy. And so at the time, and is still in effect today, there's only certain businesses that are required to comply with this. And just to make sure that we're all on the same page, those are businesses that have annual revenues of over $25 million. And they either, they're engaging with individuals in the state of Utah or produces a product or service that targets consumers who are residents of the state of Utah. So if you are engaging in business in the state of Utah, even if you're not a Utah principal company, you are required to offer these protections to Utah consumers. And then you have to also be a business that controls or processes personal data of 100,000 or more consumers, or derives over 50% of the entity's gross revenue from the sale of personal data, or controls or processes personal data of 25,000 or more consumers. So not all businesses in the state of Utah will necessarily fall under this statute, but I think it's important for businesses to start thinking about this because at any time those thresholds could be amended by the legislature. Okay, so what do businesses have to do? Businesses must establish and implement and maintain reasonable administrative, technical, and physical data security practices that are designed to protect the confidentiality and integrity of personal data and reduce reasonably foreseeable risks of harm to consumers relating to that personal data. What is personal data? Personal data is anything that is going to identify an individual. So it is information that you might obtain as a business and collect about an individual that could later be identified back to that individual. It is not deaggregated or desegregated information that's been anonymized, but simply the data that could literally be linked back to a consumer. Businesses must provide consumers with reasonably accessible and clear privacy notices. These notices are vitally important that you get these right. And I'm going to get into later why not having a good data privacy policy could trigger other statutory violations. But the information that we're going to care about is the categories of personal data that are being processed by a business, the purposes for why you're collecting that personal data and why you're processing it, how a consumer may exercise their privacy rights, which we're going to get into in a little bit, the categories of personal data that the business shares with third parties, if any, and the categories of third parties, if any, with whom the business shares personal data. There's no form language for this disclosure statement because it is going to be unique to each individual company. That being said, it is really important that you are clear in terms that a normal person is going to understand about what kind of information you are collecting on them and then how you are using and sharing that information. If a business sells consumer personal data or uses personal data for targeted advertising, the business must inform the consumer about how a consumer may opt out of the sale of their personal data or the processing of that personal data for targeted advertising. So companies that fall under this regulatory framework must offer now an opt out from this type of advertising and this type of personal data processing. And again, we highly recommend that that be clear, conspicuous opt-out options. Businesses may not process a consumer's sensitive data without first providing the consumer with a clear notice and an opportunity to opt out of having their sensitive data processed. The code defines the difference between personal data and sensitive data. I'm going to refer people to the code to make sure that they get that right. But at the end of the day, sensitive data is going to be medical records if you are not a doctor or a prescriber of that information, national origin, race, religion, other more highly sensitive data that a person may or may not want out there. But those are all outlined in code, and I highly recommend that people familiarize themselves with the difference between personal data and sensitive data. When a consumer seeks to exercise their rights, the business must act on that within 45 days and inform the consumer after the fact of any action that is taken. So it is really important that companies that are under, again, this statute and fall within the purview of the statute, that they have a mechanism in which internally they are going to be able to respond to consumers within 45 days and clearly explain to consumers what it is they have done based on the request of that consumer. And we're going to get into the types of things that consumers can request right now. So consumer data rights. The UCPA provides consumers with several rights related to their personal data. This includes confirming whether a business is processing that data, accessing their personal data if it exists. So we have the right to know, consumers have the right to know what information the company has collected and what they currently are maintaining. So it might be one thing for somebody, for example, to turn over information about their residence or who they are in a consumer transaction where they've given you a credit card or something like that. The company may just immediately delete that data. But if that company is storing that data and keeping that data and the consumer says, what information do you have on me? The company is going to be obligated to provide all the information that they are keeping on that individual. They can also request that data be deleted. They can request a copy of that data being used by the business. And again, they have the right to opt out of a company selling their data or using it for targeted advertising. And by the way, if you have questions, I want to direct you to the Slido.com. Hashtag UCPA. We welcome your questions at any time. We have somebody here who's looking into that. And so if you have questions, feel free to ask them. Am I turning over to you now, David?
I think so.
Okay, great. And I'll be back in a little bit to talk some more.
So let me grab the water. Before we begin, I have a disclaimer I have to make that the views I express here today are not necessarily those of the Attorney General or the Utah Attorney General's office. And because this is a rapidly changing area of law, they might not be my views at some point down the road. Before I get into the substance of my presentation right now, I'd like to ask the audience a question, and please use Slido to indicate an answer. The question is, in what year did Utah first pass a law regulating the privacy of electronic communications? That's the question. We'll be back to it in a minute. Now, once the division has done an investigation, if they find that a company is not in compliance and they can't resolve it themselves informally, we get a referral. At that point, the Office of the Attorney General exercises our own independent judgment. We could decide not to pursue it, or we could decide to pursue it. If we decide to pursue it, and then we will give a 30-day notice to the company. This is a pre-filing notice that gives them an opportunity to cure. If they send us a letter saying we've cured the violation and we find that that's accurate, then we can't file a lawsuit. We can also use this 30 days to negotiate. A company could come to us and say, we can't cure what you want to cure. It's not solvable for some reason. But let's discuss how to resolve it. And usually what that would result in would be a complaint with a consent judgment attached to it. What remedies do we have if we do file a case? Well, the remedies, and as you may have guessed, filing a case is a last resort and should be something that doesn't happen by accident, only in a case where the company really wants to challenge it. I'll also point out that it was a very deliberate decision by the legislature to divide up these responsibilities and to give the companies essentially two bites at the apple of convincing two different agencies that the problem, whatever the consumer complained about, wasn't really a violation of law. But if we do go to court and do get remedies, we can get actual damages to consumers. We can also get a civil penalty of up to $7,500 per violation. And since this is Title 13, we would interpret per violation as each consumer affected by a particular instance of violation of the code. So it can be quite a sizable number if your company engages in systemic violation across all consumers. Where does that money go? It goes to a consumer privacy account, which will then be used by both the division and the Attorney General's office for investigation and enforcement purposes. Now let's talk about the history of consumer privacy rights. Why? Because this is a rapidly changing field of law, and it's important to understand how we got to where we are, and then later at the very end, I'll talk about where we may be going in the future. So I will discuss 4 things. Privacy rights before 2018. Last chance to get in a number for that question when Utah first passed an Electronic Communication Privacy Act of some sort. Then we'll talk a little bit about the game-changing European Union's General Data Protection Regulation, California's privacy laws, and finally, other states, including Utah, that have adopted comprehensive consumer privacy laws. Okay, pencils down. What are the earliest and most recent dates that people suggested for the Utah law?
I have a few dates. The oldest date, 1903. The most recent date I have is 1999. I also have a few others, 1961, 1978, and 1980.
Well, a little earlier than any of those. The correct answer is 1862. The Utah Territorial Legislature passed an act for the regulation of the telegraph and to secure secrecy and fidelity in the transmission of telegraphic messages. Not only did this require telegraph operators to accurately transcribe messages, but also restricted their ability to share them with anybody other than the intended recipient, or to profit directly themselves from the information in those messages. And you can see some of these themes that would be consistent with privacy laws today. The Federal Privacy Act of 1974 is another example of an early law, not quite as early since it's over 100 years later. That law covers the federal collection and use of personally identifiable information. It's a pretty technical law, and I would suggest that there you go to the Department of Justice has a website with a summary, an explanatory memo on the law. It's, I think, 435 pages long. So that can help you understand it. But this is where you see these disclaimers on federal websites. The next important act I'd like to note is the Children's Online Privacy Protection Act of 1998, known as COPA, and the COPA rule that followed from that, which fundamentally concerns the collection of data from and the use of that data, any person under the age of 13, and requires parental consent in the collection and limits the use, for example, for targeted advertising. That's a federal law that's enforced by the Attorney General's office, along with federal enforcers. The Health Insurance Portability and Access Act, Privacy Rule 2002, governs the use of protected health information. And then, as Lana introduced at the beginning, we have the Utah Protection of Personal Information Act of 2009, which is very similar to acts in most states that have to do with data breaches. And that act has to do with the obligation to prevent data breaches and the obligation to respond appropriately to data breaches, including providing notification if there's a risk of identity theft to consumers who are affected by the data breach, whose data has been accessed. The thing that is consistent with all these earlier laws is that they have a narrow focus and are focused on a particular privacy concern, a method of transmission, who the person is, the age of the person, whether they have medical condition, or whether there's a breach. Now we're going to turn to the modern issue of the UCPA and comprehensive data privacy laws. The first such law, and in many ways the template for everything else, was the GDPR, the EU's General Data Protection Regulation, which was passed in 2016, became law effective in 2018. This is something you will see across the board, that there will usually be a period of several years, 1 to 2 years, between the effective date of the law and the date law becomes, the date law is on the books, and the date's when it becomes enforceable and effective. That's to give businesses time to come into compliance and consumers time to get used to the ideas. The GDPR focuses on data protection by design and by default, meaning you have to design your website to protect the data and by default offer people options to either opt in or opt out, depending on what we're talking about, the use of the data. We'll talk about 7 data protection principles governing data controllers and processors. Generally speaking, a controller is the one who has the data, the company itself. The processor is an entity that is processing that data on behalf of the company, maybe software that uses the data for some reason. We'll talk about 8 data subject privacy rights, and we'll talk about extraterritorial scope, which is this. The GDPR covers EU citizens whether they're at home or abroad. It also covers U.S. data subjects in the EU. So this means that the law frequently covers U.S. businesses that do business in Europe or that may be doing business with Americans who happen to be in Europe at the time they're sending communications back and forth. As a result, large companies immediately realized they had to come into compliance with GDPR, and many of them just decided to make that the baseline. So this is when you started to see those banners at the bottom that says, you have a choice. You can either opt out of certain types of data sharing, et cetera. And many companies just decided to take that easy approach of adopting the GDPR's rules. I don't have time to really go into detail about these, but here are the 7 data protection principles under the GDPR. Lawfulness, meaning that it has to be, you're using data for a legal purpose and you're transparent about what that purpose is. You can only process the data for the purposes you've disclosed. Data minimization, which is a core concept these days, which is only keeping and collecting the processing the data you need for that purpose. And when you're done with it, not keeping it. This is highly controversial as a concept throughout the area of privacy because companies want to keep that data for other potential uses beyond what they disclosed. Of course, privacy advocates would prefer that they don't. Also, data minimization is important from the data breach perspective because the less stuff you have in your system, for example, credit card numbers from some customer you haven't had communication with in 10 years, the less likely there are to be adverse effects to a data breach. And that gets to storage, which is also on this list. Accuracy means it has to be kept accurate and up to date. Obviously, you can't intentionally keep just out-of-date addresses and things if you know there should be good ones. We talked a little bit about security. And accountability means the ability of the company to demonstrate compliance. And for many companies under the GDPR, that means having a compliance officer that will fulfill that role. It's a bookkeeping and a proof role. Okay, data subject privacy rights. Again, we don't have not a lot of time to discuss them. We have the rights, very similar. Some of these you'll see some similarities and differences from what Katie just described. A right to be informed as to what information a company has on you, a right to have access to that information, a right to rectification, which we don't have in Utah. There's a right to say to the company, you got it wrong. I no longer live at that address, or I no longer have that employment. A right to erasure. And that right to erasure is anything that they have on you, pretty much. A right to restrict processing to certain uses, such as maybe sending the package to your home address. That's a good reason to process your home address. The right to data portability, that is that when you get the data, it has to be in a usable format that can be used with other vendors. A right to object to certain types of use of the data, for example, for marketing purposes or profiling. And a right regarding automated decision-making and profiling. This has become a new issue and a hot issue. We're talking here about situations in which companies make determinations about you based entirely on automated processing. Think about an insurance company denying you insurance or maybe a mortgage being denied without human intervention. And you have a right to object to those under the GDPR and under some state laws too. So this law, this EPIC Act that affects everyone, was passed in 2016 and 2018, led to California. And what happened was that consumers started a petition drive. Now, when a petition is passed in California, the legislature cannot negate it and can only pass subsequent legislation that's consistent with it. So the legislature said, we don't want a petition here. We want to pass an act. And they worked with the group that had brought the petition to create the California Consumer Privacy Act of 2018. That act was not as robust as some people wanted, and so guess what? Out came a petition again. And this time the petition actually passed in that form. That's the California Privacy Rights Act of 2020. The rights are typically similar to the GDPR. They're pretty robust. There's the California Privacy Protection Agency that enforces them, which dwarfs both Katie's shop and my division by a significant margin. So they have a lot of people to go and act on these complaints. There's also a limited private right of action, which is unique. That's generally not afforded in privacy legislation. And in 2023, California went a step further and passed the California Delete Act, which requires one-stop shopping for deleting of data broker information effective in 2026. If you want more details about the California acts, they're available online. They would be a great CLE of their own, but unfortunately we don't have time to get into them. Following California, other states started to pass their own laws. Utah was the fifth in that process, including California. To date, 7 states currently have laws in effect as of yesterday. 11 more states have laws that are going into effect after today and before January of 2026. The bills have been passed and they're in that waiting period that I just described. So this is going to be much more of an issue across the country in the next 18 months in terms of the states involved than it is right now. There are 8 additional states that have active bills, that is, bills that are at some point in the legislative process and still could be passed. Another 10 or 12 states have had bills that just didn't succeed in their legislature, but may be brought back. The International Association of Privacy Professionals, I mentioned that I have certification from them. They have a state privacy legislation tracker on their website. So if you want to know exactly what rights each of those states protects and how they protect them, I would refer you to that source. The consumer rights are similar to what we've discussed. There's a right to access, to correct, which to delete to some extent at least, the right to opt out of certain processing, and to opt out of the sale of your information to third party. The portability right, similar to GDPR. Now, an important one is the right to opt in for sensitive data processing. This is an opt-in, not an opt-out. An opt-in is always what a consumer privacy advocate would prefer, and an opt-out is always what a business prefers because most people won't do whichever it is and will live with the default. And again, the right against this automated decision-making affecting your chance to get a mortgage, a car loan, or whatever. How do Utah rights compare? Before I discuss this, let me put an important caveat. And that caveat is that we were the 5th state. At that point, it was unclear what rights would be in other bills. Our legislature decided to take a rather conservative approach, logically enough, and to not include certain rights, some of which the right against automated decision-making wasn't even on the table. No one was discussing it at that time. So they decided we'll take an approach that we think is viable right now, and then they're requiring our office to report back in 2025 to the legislature with suggestions for changes and recommendations, which of course we'll do in consultation and work with the Division of Consumer Protection on writing. And we'll get back to that topic at the very end of the lecture. You can see that there are some limitations here. For example, for Utah, it's an opt-out for sensitive data processing as opposed to the now more common opt-in. And the right to delete in Utah is limited to data you provided to the company, data they have on you that they got from other sources, such as purchased through a third party. You don't have a right to require them to delete that in Utah. And as we discussed, this 30-day cure period, even after there's always a cure period, a period to respond, usually 45 days in most of these laws. But then this is after a notice of violation. Typical business obligations. Often states have put in requirements for the sale of PII, personal information. They're beyond what COPA requires. For example, they raise the age to 17 or include sensitive data. Transparency notice, risk assessments. Most of the statutes require active risk assessing, much like the GDPR requires accountability, to say that you've actually taken these steps and annually review them or whatever, to protect the integrity of the data from data breaches and hacks. You can see the rest of those are pretty self-explanatory. Purpose and processing limitations means you only can process it for the purposes that you obtained it for and disclose in your transparency. How does Utah compare? You can see that there are some areas that we did not include in our law. Most importantly, probably risk assessments. So that's pretty much what I have to say on this topic, but I will close by saying that the Utah law is a pioneering law, that a lot of states actually used our law as then the template for their law with these additional ideas that as they came into play in different legislatures and there became a consensus, these other things needed to be added, particularly perhaps the purpose and processing limitations, risk assessments. I'll also point out that the Utah Protection of Personal Information Act does have a restriction in terms of maintaining information you no longer need. So that's in that act instead of this act. And of course, everything having to do with disclosure of data breaches in that act too. As of last July, Utah became a reporting state, meaning that data breaches now have to be reported to our office and to the newly created Utah Cyber Center if they affect 500 or more Utah residents. So we are now learning a lot more about data breaches than we did when there was no requirement for reporting prior to a year ago. With that, I think we're going to turn it back over to Katie.
Thanks, everybody. I just want to say it is a pleasure to work with David and his team. I think just by the way he rapidly listed off so much of that information, there is no doubt about the smarts and the brain power in the Attorney General's office to bring actions in this space. I want to circle back to something that we were talking about earlier, which was the privacy statements that all companies, regardless of whether you fall under the statute or not, are required to have, in that you need to inform consumers about the way that you are collecting their data or gathering it. If you have a privacy statement on your website, I want to call your attention to the Consumer Sales Practices Act. In the state of Utah, the Consumer Sales Practices Act is what we call our UDAP, our Unfair and Deceptive Practices Act. All states have one, and the federal government has one. You can think of it as the FTC usually is enforcing that. And this is a really important statute because it basically says that you cannot be deceptive when you are engaging with a consumer. We are finding and hearing more and more stories about privacy statements that are not transparent, clear, are opaque, confusing, and ultimately are deceptive to the consumers that are reading them. Another thing that people should consider is that when you put up a privacy statement and people have transacted with you in that time, let's say it was in January of 2024, and then you turn around 6 months later and decide you want to do something different with that information that you have gathered, and now you're updating your privacy statement. Well, that is not the terms and conditions in which the consumer originally gave you that information. So companies need to be incredibly mindful that as they update that information, that they are communicating that to all consumers that have given them that information prior to that update. And potentially, and a recommended procedure would be to allow people at that point to opt out in a clear and transparent way. The Consumer Sales Practices Act is a statute that we could simultaneously enforce against a company that also violated the Consumer Privacy Act, or it could be a standalone violation for, in this case that I just gave as a hypothetical, a disclosure statement that was misleading or deceptive to the detriment of the consumer. So I just wanted everyone to take note of 1311 in the code, because I do think they run hand in hand as we're talking about consumer rights, business rights, and what businesses need to do as they're engaging in consumer transactions. I want to circle back to something else that David talked about, which is our unique setup for this statute, for our investigation process and our enforcement process. So the division has authority to, in an investigation, do the following things. We can issue subpoenas that are required to be adhered to. We can perform audits. We can administer oaths and compel the attendance of witnesses to come answer questions. We can compel sworn statements so think of it as interrogatories. And we can also compel the production of papers, books, accounts, documents, and evidence. Some businesses are not aware that we have this authority. We can enforce this authority in the courts of law. You can be held in contempt if you don't comply. I'm just making sure that everybody understands that when the division reaches out to you to ask you to produce this information, we are appreciative when people are responsive and quickly responsive. Our goal of the division in any investigation is to seek a resolution on behalf of the business and the consumer. It is not to engage in enforcement actions necessarily. Let's talk a little bit about what a typical complaint process might look like. For example, if a consumer's interacted with the business and has found that maybe they've collected information that they weren't supposed to, or they had opted out, and yet the company wasn't adhering to that opt-out request, the consumer could submit a complaint to the division detailing what they believe is the alleged violative conduct. I want to note, though, that the division has the authority to look into situations that we feel or warrant us to go in and look. We are not necessarily complaint driven. And I'm going to pause here to also say we collaborate quite a bit with our sister states. And we are seeing that more and more as these companies are engaging in broad U.S. consumer transactions, particularly now with online sales, et cetera, that when we get a complaint about a company, usually there's another state who's also received a complaint about a company. This is going to create a difficult landscape for companies that are operating in other states because, as David noted, many states have different laws right now. We hope to continue our collaborative efforts with other state agencies. We launch multi-state investigations together, but we also hope to find resolutions for companies that are engaging in a space where they might be subject to different laws. A rule of thumb would probably be to go with the strictest law that you need to engage with. Most likely that's California. But keep in mind that we will look at where you're playing and how you're doing this and how you're engaging, so long as you are adhering to the Utah standards as well. We get that there might be some confusion in this space, and where this law is new, we're looking to work with everybody to really get people into compliance. And as David noted, there is a 30-day cure opportunity. So we will review complaints that come in. If we feel like it is warranted to open an investigation, we will. Typically, we send a notice to a business to let them know that we've opened an investigation, that we've received a complaint. And we typically will informally ask for some information up front before we enter the subpoena route. We give them a timeline for complying with our requests for information. And we sometimes go back to the consumer as well so that we make sure we understand the full picture. In this unique case, when we are talking about the data privacy law or the Consumer Privacy Act, at the conclusion of our investigation, we have one of two options. As David noted, you have a first bite at the apple to hopefully to have resolved this issue with the division and the division investigator, so we can close this matter, maybe with an assurance of voluntary compliance or something like it, and get whatever the consumer was looking for resolved as well. We can, if we don't feel like we've reached a good spot and we feel like it is warranted, or maybe this is a broader, larger problem that's affecting more consumers than we feel like warrants just a quick closure of this case, we have the opportunity to refer it to the Attorney General's office for enforcement. At that point, they're going to pick up that ball, and you will be dealing with David and his team should you find yourself in that situation. For right now, though, we are talking about all of our cases that are coming in and everything that we're looking at, simply because this is also new for us to enforce. Oh, I have a thank you there. I'm also wanted to add something else, and because I'm actually relatively new to the state of Utah. I've been here for about a year and a half. And what most people don't realize, or most businesses don't realize, is that for every statute that we have, the division has the opportunity to promulgate rules. The Consumer Sales Practices Act also has rules that are associated with it that outline additional deceptive acts and practices. Anytime we find that somebody has engaged in a deceptive act that's maybe novel or new, we post it in our rules simply to give companies a warning that this is the type of stuff that we find to be deceptive, or we have found to be deceptive. It gives people an opportunity to be on notice about something that maybe they hadn't thought of or realized was going to be deceptive to a consumer, but that we at the division feel like is deceptive to a consumer and actionable. Similarly, with the Utah Privacy Act, while there is no explicit requirement that we promulgate rules, the division has broad authority under our operating statute, which is in 13.2, to promulgate rules for any of the statutes that we administer and enforce, which would include the Privacy Act. To date, we have not promulgated any rules about this. We feel like it's a pretty straightforward law. We feel like it's understandable on its face, and our responsibilities to investigate, the AG's office's responsibilities to do enforcement are pretty well spelled out in the statute. That being said, if there are places that industry feels warrant some sort of clarification, or the industry feels like we could maybe clarify, define, or would like spelled out more, we welcome that kind of input at the division because we are entitled to create these type of rules, which will be subject to a public comment period as well. But we use the rules as a mechanism to act quickly, to get information out, and to help everybody understand the regulatory landscape. So with that, I'm going to pause here, and I think we have a little bit more from David, and then we will go on from there. Thanks.
Just a moment while we change slide decks here, which is important because I have one more slide. So we'll get to that. Okay, let me get, we'll go back one there. Okay. Before I get into the topic of looking to the future, there are a few things that Katie said that I think are very important and are worth discussing. One of them is the question of regulations. And as you look at this, you've got this situation that has developed. You have 7 states, and I can go back a bit to the slide to show that to you. There. You have 7 states that currently have laws in effect, 11 states that passed laws that will soon be in effect, and 8 more states with active bills. And who knows, the other half of the states will probably in the next couple of years address this in their legislature at some level too. So many of those states have extensive regulations. Some of them run hundreds of pages and they're very specific. What is the import of those regulations to a practitioner and to us in the enforcement world? For practitioners, you have an interesting problem to address. And that is when you have not 7 laws, but at least 18 laws and maybe 26 or more laws that are similar but not the same, and one of which at least is sort of an outlier because California is both more extensive in the rights it grants and deeper in the kinds of enforcement mechanisms that it has than most of the state laws. When you're in this scenario, what should a practitioner do? Well, there are 2 schools of thought and primary schools of thought. And of course, people have some hybrid approaches. Basically, one school of thought is starting with the GDPR and going through California and then these other state laws. Perhaps the best solution is to find the most comprehensive total aggregate of rights and give those rights to everybody, regardless of where they reside or where they happen to be at the moment. Remembering GDPR applies to U.S. citizens in Europe. The second approach, and I would call that the safe harbor approach, because what you're doing is trying to create a safe harbor around all the possible restrictions and requirements that face the business. The opposite approach is to take a very sophisticated view of each state's requirements and try to use IP addresses and other technology to limit the rights granted to individuals in states to the laws of those particular states. And I would call that the specific approach. So you have a safe harbor approach and a specific approach. There are merits to both approaches. The specific approach allows a company to do more with its data and really to only give rights to citizens that legislature determined they should have, while the safe harbor approach, on the other hand, obviously protects the company better against the vagaries of changing laws. If you're in the field, you're usually getting updates on when a law changes and adds an additional right. And you say, oh, that's already covered because that was a state catching up, if you will, on what other states have. I don't have to tell my clients they have to all now change their software. So those 2 approaches exist. And I'd be curious if you can use the online feature to vote either for the safe harbor approach or the specific state approach. And we'll get back to that in a few minutes and see what people think of those 2 approaches. Now, what about these many regulations that I just described and their impact on how Utah enforces our act? Well, they are not going to be viewed as binding precedent or law for us, but they certainly are something you can argue to us. And certainly good faith compliance with regulations will be something that our office will take into account when we decide whether or not to file a case or how to resolve a case. But there is an important caveat here. One is, and that caveat is that these regulations may not be consistent, and they may also be worded in relationship to a statute that does not match our statute. So it is nice to say to us and have the conversation saying, well, I made sure my client was consistent with Colorado's regulation on this point and California's regulation on this point. So why are you having problems with me? And they say, well, that's not the same way that Virginia wrote its regulation. By the way, that doesn't match our statute anyway, so none of them are terribly relevant. So that's sort of where I want to leave practitioners. Always good to comply with as many as possible. Always good to tell us that you're in compliance if we're having a conversation with you about a referred case. But it is not a complete resolution. The best resolution would be the safe harbor approach and avoiding the problem outright. Now let's take a minute and talk about the future. This has changed. This is a highly fluid area. The laws, as pointed out by the fact that various legislatures are doing very different things. But it is also one where we can expect change in Utah, as well as expecting change nationally. First of all, as we've already addressed, the changes and amendments to our UCPA are highly likely. As mentioned, we are going to have to report to the legislature in 2025, but some of the issues that have now become kind of standard components in other laws, I wouldn't be surprised if some legislator runs a bill next year to incorporate some of those changes before we get to that 2025 report. The report itself, the fact that in our statute there is a specific section of code that gives us a reporting requirement, tells you what the legislature was thinking. This is an initial draft. We're going to start here and we'll build on it as we see fit. Recently, there's been a lot of talk about the Federal American Privacy Right Act. If you look for a draft of this bill filed in Congress, you will not find it, because it didn't get that far. There is a draft version of the bill that you can look up, a sort of markup version. It was designed, this is since the beginning of these privacy acts with California at least, there has been a discussion about should there be a federal law. There was an earlier discussion about the same topic, should there be a federal law, with reference to the data breach laws, the UPPIA and its sister laws in other states. This is an interesting problem for somebody who believes in state rights and favors generally state regulation of our own state businesses, because the countervailing point of view is that it is more efficacious for companies to be able to deal with a single federal law and a single set of standards and avoid the discussion we just had about safe harbors versus state-specific enforcement. And I would say that especially in the data breach area, there's a wide consensus we need a federal law to regulate and standardize this. And probably here too, a federal law could be a benefit as long as it has one important component, which is that it allows for state concurrent enforcement of the law and not just federal enforcement, because frequently we're operating on different wavelengths. And by that, I'm not talking about necessarily political wavelengths. I'm talking about scale wavelengths. We in Utah care a lot about 10,000 affected Utah consumers. Nationally, is that something that the federal government can spend time on when they have cases involving 50 million consumers? Not really. So having state concurrent jurisdiction under either a data breach law or general privacy law is a very important thing to the states if there ends up being a federal law. Well, the American Privacy Rights Act for a little while looked like it would be that comprehensive law in terms of privacy rights. It was not going, and as such, it would have largely preempted state laws like the UCPA, but it was careful not to preempt general consumer protection laws or other specific laws that apply to situations like protecting children online. States would have had concurrent jurisdiction under the laws that passed, with some limitations that you see in certain other federal laws. It wouldn't be the kind of concurrent jurisdiction you have in antitrust where we can just bring our own cases. And so what if there's a federal case filed? It would basically allow the states to file a case, and if the feds didn't choose to get involved, we would pursue the case. If they want to take it over, they could file their own case and do that. And that's similar to some other federal laws. COPA being an example of that, by the way. The Children's Online Privacy Protection Act has that. If once the feds file, we can't. But in any event, That law looked very likely to pass. And when I wrote this outline initially a while ago, earlier in June, I was going to talk about it in great detail and have a slide or two about what it involves exactly. However, last week it hit some roadblocks, and in an attempt to meet the needs of business advocates, stripped out some protections that then made it unacceptable to consumer advocate groups. And at this point, it appears to be dead in the water. I doubt it's going to even get formally filed as a bill. Probably it will get revisited. This built on the skeleton of prior attempts of the federal government to come up with an act that was satisfactory, and there will be future ones. What else can we do, though, to get some uniformity among state laws? Many of you may be familiar with the Uniform Law Commission. The Uniform Law Commission is a entity that drafts uniform laws with input from a lot of different sources and stakeholders. It has representatives from each state on the commission, as well as taking input from business groups, consumer groups, specialty groups, et cetera. And the Uniform Law Commission could get involved. I think there's a very realistic chance that they will get involved trying to draft a uniform law. I think it's highly doubtful that California will then pass that law, but many of the other states, including Utah, might very well pass a uniform law. And if you think this is a new thing, no, the Uniform Law Commission has been around basically in a predicate form since the adoption of the Uniform Commercial Code in the 1930s. And it has passed many, many laws on probate and other subjects that generally get passed by a lot of the states, either identically or with minor state variations, so that it's very easy for a practitioner to say, that's the uniform law, we can comply with it too. So that's what I perceive is going to happen in the front. And now let me ask what the vote was for safe harbor versus state-specific practitioner approaches to the variance of the state laws.
Folks were overwhelmingly in favor of the safe harbor approach.
There you go. That's very interesting because as of a few years ago, when there were only 3 or 4 of these, a lot of practitioners said to me, I'm just going to do it state specific. We're not going to give Utahns the rights Californians get, et cetera. But I think the trend line that survey suggests is probably the trend line that many practitioners are moving towards. It, among other things, makes your job a lot easier because there's a lot more information about what the uniform whole should be than trying to go through and finding the individual ones. So with that, I think we're now properly into questions and answers. Thank you very much.
And we have a few questions for both of you. Go ahead and hit your button there.
I'm hitting the button.
The first question is actually for Katie. You talked a little bit about, both the UCPA as well as your Deceptive Practices Act that you enforce. Could you also tell us a little bit about the interplay between the UCPA and Utah social media laws?
Yeah, absolutely. So the Utah social media laws, which go into effect on October 1st of 2024, do have some additional requirements related to the use of data that social media companies are collecting about children. They have to have default privacy settings for any minor account holder. They need to engage in an age assurance process to make sure that whoever they're engaging with is an adult or a minor, and that's a very important aspect of that statute. And then once they gather that information, know whether or not it's an adult or a minor, they need to have default, as I just mentioned, the default privacy settings. And then before they share or sell that information, about a child that they've been gathering through that child's social media usage, they actually have to get parental permission to use that data in that way. That statute is 1371, and there's more information about that. We will also that is a statute that we've been asked specifically by the legislature to promulgate rules about, and those rules should be out close to the enforcement date, which is around October 1st, 2024.
Thank you, Katie. Question here for David. With regards to the UCPA, do you anticipate a more proactive or reactive enforcement approach?
Well, by definition, our enforcement approach is largely reactive. If we found that there was a general violation, for example, we learned through sister states that a particular company was simply not doing any of what it's supposed to do, or had practices that were inconsistent with most state laws, we'd probably refer that right over to the division and work with them on the possibility of investigating it. But lacking independent direct investigative authority, we have to be reactive to a certain extent. Also, we are reactive in the sense that what we're trying to do is solve problems cooperatively and in a collaborative fashion, although by the time they get to us, there's already been an attempt at that. So, as I said, typically what we would probably be looking at would be if you can't resolve the problem, give us a letter saying we're in compliance now. We would probably be looking at filing a complaint and consent judgment at the same time.
Okay, here's a question either of you can respond to. If a consumer opts out of certain uses of their personal data, and if maybe contacted a company, is there some kind of a mechanism under maybe the UCPA or methods that maybe the Consumer Privacy Division have used in Consumer Protection Division has used in the past, by which a consumer can verify that their request has been honored by the company?
Well, I think if you note from the statute, they're required to respond back to the consumer and tell them what they did when based on that consumer's request. So there is an obligation on the company to respond to the consumer. So I think first and foremost, if a consumer's requested that opt out and said, I don't want to be part of this, and then the company needs to verify or do what the consumer has asked them to do. If we get a complaint from the consumer that says, look, I still think that they're gathering this information or processing this information, we would then come in and say, okay, tell us, company, what you've done to make sure that you're honoring that opt-out provision. And then the investigation could spiral from there. I will say that a lot of my investigators are phenomenal at what they do, but they can be squirrels with nuts. And so the worst thing a company can do is at the onset be dismissive or I want to say slightly evasive in your answers, because once we feel like somebody has not been truthful and fully truthful in a response to us, it tends to want to make us continue looking deeper and deeper. And so generally speaking, I would say the best thing companies can do is communicate in a transparent and documented way with consumers. I think that answers the question.
Yep. I would add, by the way, that one factor we would tend to look at, I think, if we were in enforcement mode, is whether the company is entitled to give some extensions. There's a 45-day initial period, then extensions, and even potentially one after that. If we felt that the company was in bad faith using those extensions to frustrate consumers, deny them their rights, that would not go well. If we felt like the extension was given because they were having trouble segregating the data and really wanted to comply in good faith, then that would go well. So again, reasonableness is going to play into that, I think.
Yeah, in our Consumer Sales Practices Act, which is the 1311 statute that I referenced before, I think it might be section 20, but now I'm trying to pull it off the top of my head. We have fine factors that when we go to a court, we present about, and things like your good faith efforts, your cooperation with the division, how quickly we were able to get to some sort of resolution on certain aspects, how widespread the harm is, how much damage you've done, those types of things, the impact to Utah are all factors that we're going to look at even before we go to court or we refer to David's office, the AG's office. We're going to look at those in making recommendations. It's a good guidepost for us when we're trying to think about the type of remedies that are warranted under any circumstance, any investigation.
And back to the heart of the question, which was about how can you confirm that your data has been blood. You always have the right to go back and access your data again. So you basically say 3 months later, you come back and say, hey, what have you got on me these days?
Yeah.
And if they're not, if their company's being honest and they still have that data, then you can ask why.
Yeah.
Another question. At this point, do you all have any idea or can estimate how many businesses in Utah may fit the parameters under the UCPA?
Do we have that?
I don't think I have a number, but it's a large number.
It's a large number, but I'm not sure the exact number. Honestly, a lot of businesses, when they register in corporations, they don't provide a ton of information for us. And so it's basically a registration. And so that kind of information is not readily available to us. But that's probably one of the first questions we would ask is to figure out in determination in the initial investigation is, what's your business structure? What's your revenue? Do you fit under the statute in the first place? I will remind you, though, that if it is about your privacy disclosures, even if you don't fit under the Privacy Act, you may fall under this, you probably do fall under the Consumer Sales Practices Act.
And going back over the requirements, you either have to conduct business in the state or produce a product or services targeted to consumers in the state.
Right.
Have annual revenues of $25 million or more. Well, that's a lot of companies. Then you have to also satisfy one of these thresholds, either control or process the personal data of 100,000 or more consumers, or drive over 50% of the entity's gross revenue from the sale of personal data of 25,000 or more.
And I'd like to point out that's 100,000 consumers total, not specific to the state of Utah. So if you are a company that's transacting business outside the state of Utah and think I only have 3 Utah consumers, well, if you've got 100,000 or more across the world, you're in.
I'll point out also that nonprofits and institutions of higher education are excluded. There's some other exclusions too.
One more question. You mentioned that you work closely with maybe other state regulators or federal regulators. Do any of your investigations also involve regulators who are looking at the GDPR or foreign regulators?
We're in communication with the European Commission, with the UK's Competition Markets Authority, and other state regulators across the globe. And we certainly touch base with them periodically on topics and are sometimes alerted to situations by them.
And I would say, in addition to the states, are probably the federal agency that the division works most closely with is the Federal Trade Commission, and we do work with their data privacy group as well as other groups within the FTC and divisions under the FTC.
I have 2 more quick questions.
Okay.
How automated, with regard to the automated processes that you mentioned, David, how automated does an automated process need to be in order to really fall under some of those California prohibitions?
That's a great question. The rule against automated decision-making is a prohibition against a business making decisions about a consumer based solely on an automated process without human input. You can say, under the laws that have a right against that, you have the right to say, we don't want it to be done solely by a machine. That doesn't mean a machine won't grade you in some way or process your data in some way to pull out relevant factors, but you have a right to have a human being look at it at the end, so that in those states that have that right, so that if there's a mistake or simply you make a plea, yes, I know that my credit scores aren't great, but here's why you should give me that home loan anyway. I just recently got this great job or whatever. So we're talking about a right against totally automated decision making.
And finally, you mentioned, or we discussed, you have a certification from the IAPP. And how important is that, or how valuable is that to practice in this data privacy space?
Okay, well, the International Association of Privacy Professionals is probably the premier organization around the world for people who are engaged in the area of privacy, and it offers several certifications. I happen to hold the Privacy Professional Certification for the U.S., which is primarily directed to lawyers who deal with U.S. laws. There's another one for the EU. There's a Certified Privacy Professional Manager, which is for the person in the company whose role it is to make sure that privacy is a part of the build and design of the company. Again, privacy by design and by default, as I talked about earlier. And there's another technical one, CIPT, for the technicians in the IT department who need to know how to do these things.
And I believe there's a new one for AI as well.
Yes, they have a new one for AI. That is correct.
And that is the end of our questions. We appreciate everyone for tuning in today, and you will receive 1 hour of CLE for those who participated with the entire presentation or were here with us today. Thank you.
You can
very
also
much.
find more information about all of these statutes that we've talked about at dcp.utah.gov. That's again dcp.utah.gov, and the AG's office, I think, has a similar.
We do. And Lana, do you remember that?
If you go to the Utah Attorney General's website under resources, we have information under data privacy as well as information under financial crimes and protecting yourselves from those.
Thank you.
Thank you.